The right to bear arms versus Firearms, a weaponized lexicon. What if I told you that the Second Amendment is intact, but useless, simply because they changed one word? In this episode, we expose how legal language, particularly the substitution of firearm for arms, has subtly but completely shifted the interpretation of your constitutional rights. If you've ever wondered how your freedoms were eroded without legislation, you'll want to see what the UCC, the courts, and Black's Law Dictionary all left out. The Second Amendment to the United States Constitution guarantees the right of the people to keep and bear arms. Notably, it does not mention firearms. This distinction is not incidental. It is linguistic, legal, and deliberate. In the realm of constitutional interpretation, every word is presumed to be chosen with intention, especially in foundational texts. Arms is a broad term, encompassing all weapons suitable for defense or combat, whether manufactured, improvised, or even unregulated by statutory law. In contrast, firearms is a legal term of art, heavily defined and regulated by statutes such as the Gun Control Act of 1968, 18 U.S.C. Section 921A.3, and enforced by the Bureau of Alcohol, Tobacco, Firearms and Explosives, ATF. This statutory definition narrows the scope of the term arms to a specific, registrable subset of weaponry, subject to licensure, forfeiture, and legal classification. This semantic shift, from arms to firearms, represents more than mere bureaucratic convenience. It functions as a jurisdictional trap. By encouraging individuals to refer to their weapons as firearms, they are involuntarily entering a domain of regulation governed not by the Second Amendment, but by federal administrative code. Once the term firearm is used, one has legally entered the commercial code jurisdiction, a world of licenses, serial numbers, and enforceable statutes. Additionally, when a person fails to challenge the use of the term firearm to describe what they consider their constitutionally protected arms, they may be deemed to have contractually agreed to the regulated definition. This is particularly relevant under UCC Article 9, where definitions and language carry the force of law once they are incorporated, explicitly or tacitly, into a contractual or commercial setting. Thus, to maintain one's Second Amendment protections in legal form, one must be extremely precise in language. Using arms rather than firearms is not semantic pedantry, it is a constitutional necessity. This is also why the ATF is not named the Agency of Tobacco, Arms, and Explosives. The omission is structural. Footnote: this section explains how linguistic precision between arms and firearms affects constitutional standing and legal jurisdiction, with direct implications under statutory and commercial law.